We'll now call the next case, which is Marcus Reed versus State. Good morning, sir.
Good morning. May it please the Court, I'm Justin Blakely from Orlando, and I represent the appellant. I'd like to reserve 3 minutes for rebuttal.
Sir.
Your Honors, this appeal is about
You're with Mr. Wesley's office?
Yes, sir. Ninth Circuit.
Yeah, I'm just curious, did he decide that you all would keep this case for a particular reason?
Well, I lost the trial, Judge, so I thought I'd appeal it.
Oh, okay.
I think it's a great experience.
Yes, sir. The appeal is about Mr. Reed being mistakenly stopped by the police, that's acknowledged by them in the record, and then being improperly impeached by a previous juror in his case. We had 2 jury selections in this case. During the lunch hour, the first...
We're familiar with the facts.
Okay. And the issue then is that when is allowing that juror to testify in the trial. The statement, just so the court has that in front of it, that Mr. Owsley, the juror that was allowed to testify to, was, no, we ain't going to say that. We're going to say that he drawled it. That statement.
Let me ask you this. Maybe the state can explain how that's relevant or how it should have been admitted, because I'm having trouble seeing any relevance in the statement. My concern from your argument is whether it's harmless error or not. Why do you believe it's harmful? Let's assume it's error.
Okay. Well, the juror himself, Mr. Owsley, said that before he even heard the facts, he believed, based on that statement, he couldn't be a good juror. That's on page 92 of the trial transcript. So the juror's own, the witness who heard that, his own testimony, implies that it's harmful error. The trial judge, when he heard that the juror heard that statement, struck the panel in the first jury selection. So the trial judge thought it was harmful error.
Well, no. I think you're misconstruing the concept of harmful error, but because it's an interesting question in my mind, because I'm not sure exactly what that statement means.
Well, at least the trial judge...
Looking at, in terms of the evidence presented, why is the admission of some statement that really is unclear as to its meaning, why would that be of such a significant that the result of the trial would be different absent the admission of that evidence?
Well, in the case law that we cited, in cases where there's a credibility determination between one side and the other side, like in this case, where the defendant or appellant was the only one saying that there were children and that he got the gun from the children, and the police officer said that he didn't see any children in that area and there aren't usually children in that area. When there's a credibility determination, any improper impeachment is looked at more closely. And this, in the context of this particular improper impeachment, you had a previous juror. I think the fact that it was a juror is important. Someone who had sat in at least a similar...
Would it have been a defense that he got the weapon from children?
Yes, it was a necessity defense.
Necessity?
Yes, sir. If he got that gun to prevent the children from hurting themselves with it, and then as he testified was going to go dispose of it at his aunt's house, who also testified he was a deputy sheriff, then the only reason he possessed that gun was to prevent a greater harm than actually possessing the gun. So that would have been the necessity defense. But in the context of this impeachment, I think the fact that it was a previous juror, someone just like the panel there who was testifying to it, who actually said that based upon hearing that in front of the jury, he was allowed to say this, based upon hearing that he couldn't be a good juror, what's the jury to think? If this guy who was just like us couldn't judge the appellant fairly based upon hearing that statement, how were they to judge him fairly? That was just a tremendous hit to Mr. Reed's credibility in the case. And also it implied that there had been further or additional proceedings in the case. Traditionally, juries aren't told that there were other motions on the case or that there was a mistrial in the case, and it allowed the jury to know that something else was going on in the case, that some other proceeding had happened before.
How did the evidence come into trial? What was the state's lead up to getting that statement into evidence?
Well, they didn't present it till after Mr. Reed testified in their rebuttal case. And then they brought him up and explained how he heard Mr. Reed make that statement.
I think the question is, what was the state's theory of admissibility? Is that...
Yes. What?
The state attorney says in the record, and it's in the discussion on the motion in limine, that the juror believed that Mr. Reed was going to lie on the stand when he heard that statement, and the state attorney himself believed that Mr. Reed was going to lie on the stand based on that statement. And so he thought that the juror ought to be allowed to get on the stand and say that statement, because the obvious implication from that statement is that Mr. Reed was going to lie on the stand. And that's in the argument on the motion in limine towards the beginning of the record, where you can find that. So, and that's an improper purpose. You can't have just anyone coming up there to give opinions on random statements that a defendant has made. That's an obviously improper purpose, and given the context of this case...
What's the statement mean?
We don't know.
Right, no one knows.
Right. So you're just left to guess. It is a gun case. Perhaps the jury thought that...
no, but we don't know.
Right.
We're not going to speculate
guess.
as to what it meant, but from the context itself of the statement, no one could... It's an amorphous statement. No one knows what that means.
Right. The only thing they knew for sure is that when Mr. Owsley heard that statement, he didn't think he could be a good juror, and that was presented in appellant's case. So we knew Mr. Owsley didn't like the statement, but we didn't know why he didn't like it or what it had to do with anything.
But what's being appealed isn't the juror's testimony as to what his thought process was. It was the actual statement. I think that was the argument that you made in your brief.
Yes, but that statement and its total effect on the jury, I think you have to include the additional testimony from Mr. Owsley, because that was presented to the jury too. That helped add emphasis to the statement.
I don't know that was really accentuated in your brief.
Yes, Judge.
Okay, talk about the motion to suppress briefly.
Okay. We had a couple of issues in the motion to suppress. The first issue was whether the BOLO was too general. We had a black male, black clothing, pink bicycle. That's kind of all that was in the BOLO. And in fact...
In what case, what's your best case?
Bellamy's my best case on that, Judge. Bellamy has a similar description. In Bellamy, it was a black male wearing dark pants, black and white shirt, and a jacket who sold drugs. It's almost exactly what we had in this case.
Well, but you also have proximity, you've got direction of travel, and mode of travel, and, time.
That would be the
This
one...
guy was riding a bike at in the direction that would have been away from the alleged drug transaction, at a distance that would have been about the distance that a bicyclist would have covered. So, I mean, it seems like that those are factors that one can consider as well, not just the factors that you recited.
Right. Those are, right, the proximity, the location, those are factors, and the state cites it. We cited it at the trial court level. The King factors or the Hunter factors, those are factors you consider in determining whether the BOLO or the stop was reasonable. But Bellamy covers those factors too. The only difference, I think, between Bellamy and this case is that in this case the description included that the suspect was on a bicycle and there was no mode of transportation in Bellamy. So I think those cases are pretty close. But importantly, the police officer admitted that before he stopped the appellant, he knew the color was different than was in the BOLO. I mean, I know the colors are close, and so if he had stopped him when he still wasn't sure if Mr. Reed's bicycle was pink or purple, that'd be one thing. But when he stopped Mr. Reed, he knew he was stopping someone on a purple bicycle, which is a different color than the pink bicycle. So he ignored that factor in the BOLO, which I think is important. The other issue we have on the motion to suppress is that there was no testimony of what the initial police officers observed.
If an officer gives a BOLO goes out and it says that it's a light blue, black pants, light blue shirt, and the person sees someone and it's a different, it's not light blue, it's a light purple. You think that makes the stop illegal?
I think, yes, Judge. I think if he knows that the color's different, the officer, if there's time, I mean, if there's no other exigent factors, should radio back and say, hey, could it have been a purple shirt? I think this case is proof that the color is important, because he ended up stopping the wrong guy, because he didn't stop someone on a pink bicycle, he stopped someone on a purple bicycle. Just kind of quickly, the other issue in the motion to suppress was, did the initial police officers have a reason to believe that a drug deal occurred?
That was never raised below, right?
Judge, I believe it was. I was reviewing it. I believe we raised that at the trial court level. I don't have the page in the record where we did that, but I thought we did.
Well, perhaps you can find that and let us know when you get back up.
Okay. So just briefly on that, if the initial police officers didn't have a reason to believe a drug deal was occurring, then the second police officer actually made the stop, couldn't rely on the fellow officer rule to make the stop, because you have to have the first police officers had to have a reasonable, articulable suspicion of criminal activity for the second police officer to rely on their observations. And I think the only record evidence we have of what they observed is that they observed a drug deal, and we don't know why they thought it was a drug deal, and then they gave the description of the person who they saw make the alleged drug deal. So it would be our opinion from the case law and JP v. State that we cited, that there would need to be more, that they need to say, either through hearsay from the police officer who testified at the motion to suppress, or actually bring in the initial police officers as to what they actually saw to believe that a drug deal had occurred. Thank you, Judge.
Thank you.
May it please the court, my name is Pam Kohler. I represent the state of Florida. I'll start with...
Concede that that testimony had no relevancy.
In fact, it was so irrelevant it was harmless error, I would basically say. I have no clue. The judge apparently was right on track with the prosecutor saying, oh, yeah, he definitely was going to lie. That's what I would get from it. I have no clue where they're getting that from.
I think we have to make an independent analysis of whether it's harmless error or not, but it is a little bit frustrating or aggravating when you have a prosecutor below who says, Judge, this is really important. The jury needs to hear this. And then you come up here on appeal and understandably say, Judge, this was meaningless.
That's why we have the harmless error rule, Your Honor. That's the only thing I can tell you. That, and I think part of it was, and for some reason the prosecutor didn't anticipate this, but the prosecutor tried to get the former juror to testify as to what he thought this meant, and of course that's pure speculation, and it's not admissible. And the judge rightfully sustained the objection to that, so the jury never heard that. And maybe that's why the prosecutor thought it was so relevant, that this jury automatically thought the defendant was going to lie. But clearly that was proper, objection was sustained, and the jury never heard that testimony.
So this was a case where the only thing for the jury to resolve is whether the defendant was credible or not, because the police officer testified, wasn't really impeached. The only question was whether the defendant was telling the truth when he said he took the gun from kids to deliver it to a police officer so the kids wouldn't get hurt. So the only thing that mattered in this case was the defendant's credibility, whether it established a necessity defense.
Right.
Did this rebuttal witness's testimony tend to imply that he was not a credible individual?
I don't think it implied anything. I mean, I really think it was meaningless. Plus, as I pointed out in my brief, the defendant wasn't able to get his story straight himself with what he told other people. Contrary to what defense counsel stated in his reply brief, the defendant testified initially he was on the way to see his aunt, not his girlfriend. But when he saw the gun and he saw the children and he picked up the gun and then was going on to his aunt's, he initially, on page 65 of the trial, testified to the jury, I was going to my aunt's house. And that's why I was on, I forget what road it was, and I turned on to this road, which ended up with me being stopped by the police. And then apparently he told his cousin he was on his way to his girlfriend's. So already we've got testimony at trial from the defendant and his own
Well, he
witness.
could
that
have been going
could-
to his girlfriend's house initially, and then once he got the
That's not what he
gun-
testified to, Your
Maybe
Honor.
his cousin was his girlfriend.
And she testified she was not. She testified that the girlfriend did not live at their residence. So he specifically testified on page 65, he was going to his aunt's house. He never said anything about going to his girlfriend's house. So
Let me ask you this. My question was whether this implied that the defendant was not credible, Mr. Ousley's statement. Now, the prosecutor below certainly believed that it implied he was not credible.
true.
So, should we agree with the state below?
No, I like I said, it's meaningless. I have no, of course, there was no context for the statement. It's not like this juror overheard that they were talking about the case, the trial, and then said, well, if they ask you this question, this is what you need to say. He could have been talking about, going to see his aunt the next day. I mean, who knows what he was talking
I'm
about?
trying to figure out what law school would one go to where you would believe that a juror from a prior case's impressions that the defendant was intending to lie would be admissible. Where do they teach that?
I don't know. Especially since that juror admitted he didn't want to be on the jury because if he wasn't working, he wasn't getting paid. So he would have lost money to be sitting on that jury. So, I mean, becoming a witness in a case obviously would mean you couldn't be a jury in that case. I don't know. I don't know. But I think it was so meaningless that it was harmless error at this point. And that's why we have the harmless error standard for review. Moving on to the motion to suppress, under the fellow officer rule, basically every officer in that's working on the case is basically considered that their knowledge of the two officers who were watching the drug transaction is imputed to everybody. So at that point when he...
Is there any significance that this was during the day, and so that the description of the bike would presumably not be impacted by lighting conditions, so that the difference between the color would be significant between pink and purple?
Well, Deputy Nelson testified that. He said from a distance it looked pink. It looked like a dark pink. He said it's only when the defendant got closer and he basically sat there on his patrol car waiting for the defendant to approach him on the bike. He said as he got cold, and then he realized it's more purple than pink. But he said, I don't know, somebody else may have called it pink from a distance. He said, I can't speak for them. And he said, so when I saw that, that's what I'm thinking is like someone else could have thought this was pink from a distance. So that's why he considered to still be consistent with the bolo he was given by the two deputies who were watching the drug transactions down the street.
In the motion to suppress hearing, the primary focus of both sides was what Deputy Nelson knew, and was there anything brought up before by the defendant that the state also needed to show that the first officers had enough information to conclude that there was probably a drug transaction taking place?
He did argue that in his motion, as I recall. I think he had two things that he was arguing. Number one, that there was insufficient, the bolo was insufficient. Number two, that the officer, I guess something to the effect of that Deputy Nelson didn't know what they had actually observed, and that was insufficient as far as giving him the right reasonable suspicion. But clearly, the focus of everybody during that hearing was whether or not the bolo was specific or not. And that's what the trial court ruled on. And the trial court, I don't think, even addressed any other issues. And there was no objection or request for further elaboration by the defense. So, but I do recall him arguing something about that in his motion. I think we've talked about all the criteria. And if there's any questions that this court may have beyond that, I would rely on my brief, and I'd ask you to affirm. Thank you.
I think we should have had the prosecutor come up and argue this.
I found it in the record where I argued at the motion to suppress about the lack of reasonable suspicion based on not knowing what the first two deputies saw. It's in the record 138. page 138. It's actually the first thing that we argued on the motion to suppress, and I cited the case in the lower court of United States v. Hensley, which I didn't cite in my brief, but from my recollection of Hensley, it stands for the proposition that I was arguing today.
You didn't argue it in your brief, you can't argue it now.
Okay. The point below at the motion to suppress and the point now is that with no testimony of what those initial officers saw, the fellow officer rule can't be relied upon. I mean, the whole point of the rule is that you have the collective knowledge of all the police officers involved in the case, and we didn't know what the collective knowledge was because it was never testified to. It'd be like at an initial appearance report, if an officer just says, there was probable cause based on what someone else told me to believe a crime was committed, no judge would find probable cause unless he knew what the other person told him. Or he or she knew what the other person told the police officer. We need some information as to what those two deputies saw, and there was none testified to. Short of that, I'd rely on my brief and the arguments I made initially if there are any more questions.
Thank you so much.
Well-argued case.
We appreciate your help. All right, we'll take up